Good morning, everyone, and welcome to the Committee on Finance. I hereby call this meeting to order. The time is 10:03 on Monday, July 20th, 2020. And pursuant to applicable laws and my determination that attendance by remote means is necessary because of the in-person meeting not being practical and prudent due to the declared public health disaster caused by the COVID-19 pandemic, this meeting will be conducted by video conference. For questions during the meeting, Alderman, please use the raise your hand function to indicate when you have a question. Members of the committee will be given preference first on calls, but if you wish to make a point of order, point of information, or point of clarification while one of your colleagues is speaking, please try to use the raise your hand function, and I'll watch for those as we move forward, and then unmute your microphone. We will now have a roll call to establish quorum. If you guys would please unmute your microphone when your name is called. And we'll start out with Alderman Hopkins.
Present.
Alderman Dow.
Here.
Alderman King.
Present.
Alderman Sawyer.
Here.
Alderman Mitchell.
Hey, Lois.
Alderman Harris.
Chairman, did you
Alderman
hear me?
Beal. Alderman Beal. Alderman Sadlowski Garza. Alderman Thompson.
Present.
Alderman Cardenas. Alderman Quinn.
Here.
Alderman Burke. Present. Alderman Lopez. I think you're on the phone version. Alderman Moore.
Present.
Alderman Curtis.
Present.
I see Alderman Curtis there. Alderman O'Shea. Alderman Brookins. Alderman Scott.
Present.
Alderman Burnett. Alderman Irvin.
Present.
Alderman Tabares. You're on there. Alderman Taliaferro.
Present.
Alderman Raboris.
Present.
Alderman Irvin, I have you on there. Alderman Austin. Alderman Villegas.
Present.
Alderman Mitz.
Present.
Alderman Spizzato.
There.
Alderman Napolitano. Alderman Riley.
Present.
Yep. Alderman Smith.
Here.
Alderman Tunney.
Here.
Alderman Osterman.
Here.
And Alderman Silverstein.
Here.
Vice Chairman Hairston.
Here.
I see you. And Alderman Wagsback is here. Ladies and gentlemen,
Yeah,
we have a quorum necessary.
We have two more, I think Alderman Mitchell and Alderman Burke were.
I had Alderman Burke.
Alderman Garza present.
Okay.
Alderman Mitchell present.
Alderman Tabares here.
Alderman
Got you.
Irvin present.
Alderman.
Uh,
Lexi, can you get that?
Okay, I have everyone except Alderman Cardenas, Mitchell, Austin, and Napolitano. And I see Alderman, let's see, Alderman Vasquez, Nugent, Cardona, and Coleman are here as well. And let me just check the other screen. Okay.
People,
Well, we
can
have a
people please
quorum.
mute?
And thank you everyone for coming in this morning. You should have in front of you the minutes per Rule 45 of the June Committee on Finance meeting. Does anyone have any questions or changes? May I have a motion to approve the roll call used to establish quorum?
So moved.
So moved.
So moved by Alderman Hairston, or Vice Chair Hairston. All in favor signify by saying aye.
Aye. Aye.
All those opposed?
Aye.
In the opinion of the chair, the ayes have it and the motion carries. Ladies and gentlemen, moving to communications from the Department of Law. Item number 2 is the monthly report of judgment and verdicts and settlements from the Department of Law for the month of June 2020 and will be placed on file with the clerk. Those were forwarded to you, and if we have any questions, we can speak to the law department to discuss those. There are 2 items on there from last month and then this. Alderman Raboris. Go ahead, Alderman Raboris.
Mr. Chairman, on the matter with the settlements, I want to be voted as a no on the FOIA issue with $500,000. That's all.
Okay, we're not up to that one yet, but I'll make a note of that when we get there.
All right, thank you.
Okay, ladies and gentlemen, items 3 and 4 are authorizations for the payment of various small claims against the city and the denial of payment of various small claims against the city. If there's no objection, these items will be placed in the omnibus. We will now move to the supplemental agenda, and we're joined by First Assistant Corporation Counsel Renee Rodney for testimony on these 2 matters. We have 2 matters up today on the supplemental agenda. 1A is Manuel Barrios, Brandon Fuller, Savannah, Washington versus City of Chicago in the amount of $4.95 million. And item 1B is Charles Green versus the Chicago Police Department in the amount of $500,000. And Renee Rodney will start out with the Barrios case.
Thank you, Chairman. For the record, my name is Renee Rodney, First Assistant Corporation Counsel. Thank you for allowing me to testify this morning. The first settlement is Manuel Barrios et al. 1983 class action lawsuit filed in March 2015 by vehicle owners concerning CPD's asset forfeiture procedures. Plaintiffs allege that the vehicle office of CPD's asset forfeiture unit engaged in a pattern rather than providing such vehicle owners with a forfeiture hearing as required by statute. The asset forfeiture unit would contact the vehicle's lien holder and then transfer the vehicle to the lien holder without the owner's prior knowledge and in violation of due process rights. The law department recommends settling the case by creation of a claims made fund of $4.95 million, inclusive of attorney's fees and costs. Plaintiff's Fuller and Washington's vehicle was seized for potential forfeiture after a passenger therein was arrested for possessing a felony amount of marijuana. 1 month later, a court entered a finding of no probable cause in the passenger's criminal proceeding, and the case was dismissed. Fuller and Washington allege that AFU contacted the lien holder of the vehicle almost immediately after it was impounded and encouraged the lien holder to repossess the vehicle. Fuller and Washington claim that they made several attempts to recover their vehicle, but their efforts were unsuccessful. The vehicle was released to the lien holder. Under state law, CPD must determine if forfeiture is warranted and then either send the vehicle to the state's attorney's office for a probable cause hearing and subsequent forfeiture hearing, or otherwise release the vehicle to the owner or the lien holder. An internal investigation by CPD confirmed that the practice plaintiffs complained of was occurring. It ended in July 2015. CPD's procedures regarding vehicle releases were revised to ensure and make explicit that lien holders were not provided with any preferential treatment in the recovery of vehicles impounded for alleged drug-related purposes or offenses. Thereafter, all vehicles seized by CPD were either submitted to the state's attorney's office for a probable cause determination or released to the owner. After the court denied the city's motion to dismiss in part, the city worked with plaintiffs' counsel to identify appropriate members of the putative class by analyzing the facts surrounding the seizure and processing of each vehicle. The agreed upon putative class now consists of only 356 vehicles rather than $22,000 initially claimed by plaintiff. In addition, the parties agreed upon a class period from March 28th, 2013 to August 1st, 2015. The class period was determined based on when plaintiffs filed their complaint, the relevant statute of limitations, and when the practice ended. Each individual settlement class member will be mailed a claim form at their verified address. Each claimant then must submit a separate claim form establishing their membership in the settlement class within 4 months of City Council approval or by November 18th, 2020. Any residual funds after payment of all approved claims, incentive payments, and court-approved fees and expenses will revert back to the city. Are there any questions?
No questions.
Okay, seeing as there's no questions on this item, may I have a
Chairman?
motion to,
Chairman,
yes. Alderman Burke, yes, sir.
I just have a question for council. Is there an estimate of what the lawyer's fees are on this case?
Yes. Of the $4.95 million, we anticipate 33.33% of that amount will go to attorney's fees, which is approximately $1.65 million. And that's plaintiff's attorney's fees.
And is that subject to approval by the court?
Because this is a putative class action, the settlement in principle was already approved by the court, obviously subject to city council approval. So yes.
So the fees, those fees have been approved by the court already?
Yes.
What court is this pending in and who's the judge?
It's in federal court in the Northern District of Illinois, and Judge Gotzel is the presiding judge.
Thank you.
Chairman Burke, are you on a cell phone or a phone?
A cell phone, and I don't have a button to say my hand is waved.
Okay, so I'll watch if folks are on the phone. Sorry about that.
Thank you.
Alderman Thompson?
Thank you, Chair. What is the law firm?
Representing plaintiffs,
Yes.
plaintiffs' counsel is Paul Little and Edward Moore, M-O-O-R.
And did we have outside counsel or were we doing it in-house?
We're represented by outside counsel in this matter.
And who is that?
The Taft Law Firm.
Okay, thank you.
All right, any other questions?
Well, as long as Alderman Thompson brought that up, Mr. Chairman, what are the fees for outside counsel?
I do not have that figure available in front of me, but we can aim to find that out. I know we're anticipating a vote. I don't have outside counsel fees to date, but we can
Well,
try.
I think the point is if the plaintiff's attorneys are going to get 1.9 million and the counsel representing the city would, in theory, get the same, that means that almost all of the settlement will be eaten up by fees.
Well, the claims made fund of 4.95 million does not account for outside counsel fees incurred by the city in the litigation.
So they've already billed and been paid on this case?
You know, they bill on a monthly basis and are paid as they submit their bills, yes.
Well, is there an estimate then on what the fees have been? This was pending in court since 2015. Is that my understanding?
Yes, we're attempting to get an answer to that question, the amount of outside counsel fees. I just don't have it at this very moment. But those fees would be paid separate and apart from the 4.95 million.
But I think as a matter of interest, the members would probably like to know whether most of the settlement represents fees as opposed to reimbursement to parties that have been injured.
Sure. Of the 4.95 million, as I said, approximately 1.65 million of that amount will go towards paying plaintiffs' attorneys' fees. Then the 3 named plaintiffs receive an incentive payment of $5,000 each, which totals $15,000. And then there's a claims administration fee of approximately $15,158. So that leaves approximately $3.27 million in the so-called settlement pot to be distributed among the 356 vehicle owners who submit a claim that's approved.
Is there a limit on what the plaintiffs can recover? The individual claimants?
Yes, so they would be entitled to the Kelly Blue Book value of their vehicle at the time that it was seized by CPD.
And is there an estimate of what the average is on all of those?
Yes, the average value of the vehicles for which we have a fair purchase price is approximately $9,891.66.
So we're estimating then that the 300 and some injured plaintiffs would get, let's, for the sake of argument, say $10,000 a piece. What's the math on that? 300 and how many times 10,000?
Well, 3.27 million is allotted for that purpose.
Did
To
you
the
say
extent
there's
that-
365 plaintiffs that are involved here?
356. 356 vehicles. Conceivably, a claimant could have had more than one vehicle seized. So there's not necessarily 356 claimants, but there are 356 vehicles at issue.
So if my rough calculation is correct, that would be about 3.2 if each of them had only one car, or somewhat more if they have more than one car. Is that right?
That's right.
Thank you.
Thank you, Chairman. Alderman Scott.
Thank you, Chairman. Good morning, Renee. Just to follow up, I wanted to make sure that I heard correctly. So we're going to do Kelly Blue Book value for each of the vehicles. We're not going to do, well, just answer that first.
And that is correct. And that determination came out of motion practice during the litigation. The city took the position initially that the value of the vehicle should be less any amount owed to the lien holder. The plaintiff argued that the appropriate measure was the fair market value of the vehicle when seized by CPD. The court sided with the plaintiffs. So we had to settle on accepting the fair market value of the vehicle as a term for distributing the funds under the in the claims fund.
Okay, thank you. That answered my question, Chairman. Thanks.
Thank you. Alderman Sawyer, were you good?
Yeah, I was good. My question was answered during the course of that exchange. Thank you.
Okay, thank you, sir. May I have a motion to approve using the roll call used to establish quorum?
So moved.
So moved by Alderman Curtis. All in favor signify by saying aye.
Aye.
All those opposed? In the opinion of the chair, the ayes have it, and this motion carries on the Barrios case.
Mr. Chairman, Alderman Burnett want to be added to the roll call.
Okay, thank you, sir.
Mr. Chairman, Alderman O'Shea would like to be added to the roll call also, sir. Thank you.
Alderman Beal as well.
There you are. Okay. I saw each one of you come on, so I have you listed, but thank you for jumping in there. Our second case is the Green case, and Renee Rodney will speak to that issue now. Alderman Sadlowski Garza.
Thank you, Mr. Chairman. I just have I'm not a lawyer, nor do I pretend to be, but I mean, let's not forget that Mr. Green spent 24 years of his life in jail for what he alleges a crime that he did not commit. I find it egregious that it's so hard to get records, police records that were years and years that were from years ago. We have to start doing this a different way so that we can do things electronically where it's not going to cost us $8 million to find out or to clear somebody's name. Currently, is it you have to go through paper records? Is that how this works right now?
Alderman, for the older records, which have not yet been digitized, yes, that would involve paper files. But there are a number of records that have been digitized in more recent years. So that process for identifying, scanning, reviewing, and redacting can go much quicker than if the files only exist in hard copy form, just based on the age of the files. I will say in litigation, CR files from decades ago are often requested in what we call reverse conviction cases if the plaintiff is alleging that he was wrongfully convicted and would like to see any disciplinary histories of the officers who were involved in his case. So those are records that are produced every day in litigation. So they are made available in litigation, and they can be made available through a FOIA request if appropriately requested.
Right. So Mr. Green, he's going to get a percentage of this $500,000, and then we'll never see these CRs that he's requesting. Is that correct?
Are you speaking of the ones from 1967 to 2011?
Right.
Right. CPD would not undergo the process currently ordered by the court that they have to produce all CR files. But CR files are still produced in other FOIA requests. So for example, someone could submit a FOIA request today and say, for Officer Smith, I'd like to see his disciplinary records from 1990 to 1995. And if there were no appropriate exemptions, then CPD would turn over those in redacted form.
So did Mr. Green try to FOIA the records of the officers that were just involved in his case? Wouldn't that have been a much smaller and more doable ask than, or is it because it was 1967 when he went to jail? I mean, I don't understand why he's looking for every single misconduct report on police. Why wouldn't he just focus on his case and his case alone?
I can only say that his litigation strategy was to request all closed CRs for all CPD officers dating back to 1967, and that request was never narrowed during the litigation. With the exception of the court saying, CPD, you have to turn over 2011 to 2015. So,
and that actually won't help him because he was convicted in, I believe, what is it, 1967 or something like that, correct?
No, I don't think it was that far back. I believe he's in his mid-30s now, so his conviction was from the late 80s, early 90s.
So he'll never be able to prove his innocence?
As I understand it, he did apply for clemency in 2014, and his petition was denied in October 2016. He then sought review from the Cook County State's Attorney's Office Conviction Integrity Unit, but that unit reviewed his case but declined to act. So all of Mr. Green's avenues for post-conviction relief were exhausted.
Thank you so much. That's all my questions. Thanks.
Thank you. Alderman Brookins.
Thank you, Mr. Chairman. So I guess my question becomes, it appears that this situation is not going away. And that even if we settle with the plaintiff in this particular case, more plaintiffs will start employing this strategy. So therefore, my question becomes somewhat on the line of Alderman Garza, is then going forward, in order to save the taxpayers some money, is there any thought given to just making all of these records available in a searchable file online to anybody who wants to look at it?
That is certainly being considered, Alderman. I don't have a finalized plan to present to you, but that is being presented. And as far as, this continuing to happen, the city certainly has defenses to various forms of FOIA litigation. Like I said, if someone tomorrow submitted the same request that Mr. Green requested, CPD would review it and respond in kind. One of the shortcomings in the Green case is that CPD did not respond within the allotted time frame, and the lower court refused to acknowledge certain arguments raised in the litigation because CPD did not respond within the 5 days. So I can say between 2015 and today, CPD has significantly improved how they handle FOIA requests. These are tracking software. It goes through multiple layers of review. All of its responses and exceptions are put in writing to be documented. So it's leaps and bounds ahead of where it was in 2015. So we can avoid litigation that arises from a failure to respond at all, which could potentially hamper our ability to make certain arguments. So that's not to say people won't attempt to sue us, but as long as the city and the city departments are doing what they're required to do under the statute within the allotted time frame or the extended time frame, we can certainly better defend against litigation where we think we have properly raised an applicable exemption.
So I guess my question becomes, though, it appears that the settlement for this particular plaintiff includes that he get these documents. Is that correct? To 1967?
I'm sorry, Alderman, can you repeat that?
So it appears to me that as part of the settlement that he is going to get these records?
He has been getting records from 2011 to 2015.
So what does the settlement include? That stops at 2015, or will he get the records all the way back to 67?
No, as part of the settlement, the parties would move to vacate the circuit court order ordering CPD to produce all records from 1967 to 2011.
So, okay, then back to, he's gonna get them up to then 2011 to today?
He's getting 4 years worth of records, 2011 to 2015, which CPD has to produce by the end of this year. So of that amount, CPD has produced approximately 23,516 CRs and has 6,214 remaining to produce by the end of the year, which it is on track to do.
All right, so the point is, I guess, still there, then it would be nothing to prevent him or his attorney from posting those records online in a searchable form to whoever wanted to look at them. And if that being the case and the cat is already out the bag and these records are already then in the public view, then it would just seem that the city would, for anybody else who's requesting those documents, as to avoid going forward in potentially some litigation or some administrative angst, to just put them out.
Right, it is my understanding from representations by the entity, the Invisible Institute, that they are going to make publicly available the 4 years worth of records being produced as part of the Green litigation. Yes.
Okay.
And the city is certainly collaborating and figuring out ways to make records publicly available without a requester having to go through the FOIA process. That process has not yet been solidified, though.
All right, thank you.
Thank you, Alderman Brookins. And I would add that that would probably be a good spot for the Inspector General's office, since they already have the data there. Alderman Hopkins. Alderman Hopkins. Alderman Hopkins, I'll come back to you in a second. Vice Chair Harrison.
I'm sorry, Mr.
Oh,
Chairman.
okay,
can
jump
you
in.
hear me? I was
Yes, we
having
can.
some audio difficulty. Okay. Question for the court's ruling on the 5-day response. Is that just simply an opinion, or is there a basis in law where it clearly states you waive your right to the burden objection if you don't respond in 5 days? Where did that come from?
Well, I can say that that aspect of the ruling is something that we're challenging on appeal. Because the court, as I mentioned, there was an injunction in place in another case where CPD could not produce records longer than 4 years, or excuse me, more than 4 years old. So after that injunction was lifted, the court then ordered that we go back. So we are currently making some jurisdictional arguments in the appellate court that the court can't first find that CPD did not improperly withhold anything because of the injunction, and then later come back and say, you have to produce everything. So that underlies some of the arguments that we're making.
And then with regard to the legal definition of an undue burden, is that spelled out in FOIA statute, or is that case law? I mean, where do we fall back on determining whether something is a burden or not? Everything's a burden, right? Everything we do requires effort, requires research, requires work. So the key is, I think, having some clarity in terms of what is undue and excessive. And it would seem to me that whatever legal definition you want to use for that, going back to 1967, it on its face, that sounds absurd, and it sounds more than burdensome. It sounds impossible. And I say that as someone who spent some time working for Cook County government. I've been in the basement. I've been in the warehouse on Rockwell Street. I know what it looks like. It looks like that scene from Raiders of the Lost Ark at the end, where there's racks and racks of boxes as far as the eye can see, most of it unclassified, most of it unsorted. And to the extent that sorting and classification exists, it's obsolete. And the people who, stored it are long since retired and gone. So, to collect any type of records, whether it's CR records or personnel files or whatever, and a massive scale like that strikes me as the definition of undue burden. And I wonder if that came into play in the arguments that were made in this case, and if you could comment on that.
Yes, part of the relief we're asking the appellate court for is to permit the city to raise a burdensome objection in the lower court if it were sent back. And that is an objection that should have been raised. The challenge with the litigation, or that arose in the litigation, is that there was no response by CPD. So it's not as if CPD said, this is burdensome. We got sued and the court disagreed that it was burdensome. CPD did not respond and make any objection to the request, which colored the court's view of us attempting to raise burdensome when the litigation started. So that lack of response at the beginning had consequences during the litigation. And as I noted, since 2015, CPD's process for responding to FOIAs has significantly improved, so we can avoid oversights like that going forward, and have avoided in the recent past.
Well, that's encouraging. What is the current policy for CPD with regard to delineating between personnel and employment records for individual employees of CPD, which are exempt under FOIA, and those records which are discoverable and searchable and should be provided. How do we handle that distinction between those two separate categories?
I think that would go to the type of redactions that were put on the requested records. So, I mean, I don't want to speculate in a public proceeding as to the type of arguments that we would make, but each FOIA request is reviewed individually. Apologies, I'm not a FOIA expert, but we have those in the department. So each request is reviewed individually to see if it fits under any exceptions. And if it does not, we still redact, personal identifiable information, victim information, witness information, et cetera, in responding to the request. So certain privacy details would not be disclosed when we're still disclosing the actual record.
Well, okay, I appreciate that. And I think it's an important question. It's not theoretical. There's already documented cases of frivolous complaints being filed against individual officers as an attempt to kind of run up the score against them. And then 6 months later, you FOIA their file and you say, oh my God, look at this. They had 50 complaints in a 6-month period, which is part of an orchestrated campaign against them for various reasons. What protections do we have against activity like that happening?
Well, we would only produce closed CRs. So to the extent there's an allegation made that was still under investigation, and no either finding of misconduct or non-sustained finding had been entered, those would not be disclosed in response to a FOIA request, since that could jeopardize an ongoing investigation. So CRs that are turned over are closed CRs. And yes, I recognize closed CRs can simply contain 50 non-sustained complaints against an officer. It does not mean they have 50 findings of engaging in misconduct. So nothing prevents someone from requesting records in FOIA, but there are certain standards that must be met to determine if what they're requesting is something that's appropriately disclosed through the FOIA statute.
Right. Well, we all know what the ratio is for sustained versus unsustained complaints. It's frequently reported in the media. Very few complaints are sustained. And that's just the historical record, and it continues to this day. So as a surrogate for that, the sheer number of complaints against an officer is becoming an operative point. So if you can say an officer has 50 complaints, they were all unsustained, that's being used as an allegation against that officer. So whether or not the finding was sustained or not is almost irrelevant when this tactic is employed. And I just wanted to put that out there for the record. That concludes my questions. Thank you, Mr. Chairman. I'll be voting in favor of this settlement.
Thank you, Alderman. Vice Chair Hairston.
Thank you. Good morning. First, I want to say is that by the city objecting to this, that is not transparency. And I think what we're seeing here is years and years of really the police department not taking FOIA seriously. And we keep finding ourselves every month in this position where the police department willfully fails to comply and the taxpayers have to pay. And so, I need to figure out how we do this. And I guess what I'm asking is, what policy is the city putting in place so that we can make these documents readily available?
Well, I hear two things. I think you have a question about how CPD responds to FOIA now versus in the past, and then any policy going forward for making the documents available. to address the FOIA question. I mean, I wasn't here in 2015, but I understand leaps and bounds have been achieved as far as what CPD is now doing. So all FOIA requests are, as they should be, are reviewed. In any, they're reviewed immediately, and any that appear to be burdensome are flagged by a FOIA officer. Then there's a second review done by a FOIA sergeant, and those due dates are tracked by the sergeant. Reminders are sent to the FOIA officer. And I know that CPD meets with the law department's FOIA attorneys on a weekly basis to review all requests. As I mentioned, there's now a dedicated tracking software and response software for dealing with FOIAs. CPD has doubled the size of its FOIA unit, both with civilian and sworn personnel who are dedicated to receiving and responding to FOIA requests. And there's an internal review process that subjects draft FOIA responses to a quality control review. And that ensures that CPD is asserting all objections and exceptions it may have to a FOIA request. So that process was not in place in 2015, which I said created some issues during the litigation. As I mentioned, the administration working with the law department and CPD recognizes the public interest in reviewing reviewing CR files for officers who are alleged to have engaged in misconduct, and are reviewing ways to make that information publicly available. While that's happening, CRs are routinely overturned on a daily basis through FOIA requests and through litigation. I believe Alderman Garza brought up Mr. Green's situation of alleging that he was wrongfully convicted. He did not sue the city in that way, but as this body is aware, we do have a number of pending matters or settled matters where someone has alleged they've been wrongfully convicted. And in that litigation, they often seek CRs for the named defendant officers in that litigation, going back decades. Sometimes the court allows them to seek CRs for officers in a particular district during a time period in litigation. So those CRs are being made available in litigation, and yes, subject to a protective order. So I just don't want anyone to mistake the settlement as a prohibition on CPD issuing CRs to people who request it properly through FOIA or who seek it in their order, in CPD's order to produce it in litigation. This will not stop that at all. But by settling the case, we can focus our efforts on how this information can be made available in a way that's not at such an extraordinary expense to the city, but still honors the public interest in reviewing records for certain officers alleged to have engaged in misconduct.
All right, I understand your position. However, you know, it is because of the police department's failure to comply, right? This is a pattern and practice of the police department. And, you know, we keep saying, okay, well, they got a little better, you know, they're doing better than they were, but they don't seem to get it. And it does not make any sense to me. What I think they need to do is we need to have a schedule where we produce the closed cases and have a timeline. I mean, I know that can't be done, you know, overnight, but we need to have something in place, you know, because, and I've stated this every month, I am concerned about how much the city is paying out on FOIA violations in police cases. Every month, it's a couple $100,000. And Chairman, I'm going to ask that we get the amount that the city has paid in FOIA violations for the past, let's do the past 5 years. You know, because I think unless we do something different, we're going to keep getting the same. And it's just not good enough anymore. Just not good enough anymore. So that's all I have.
May I just add, the administration hears you, Alderman Hairston, and this issue is not being ignored. With respect to the amount of amounts of payouts in FOIA cases, I just want to clarify. If the city is found, if we're litigating over production of one file and the city's position was, Your Honor, in the litigation, we believe this one file was complete based on the documents turned over, but the court finds, well, city, no, there's actually one other document that was missing that was improperly withheld. So you have to turn it over. That is considered a loss for the city, and we have to pay attorney's fees in that case. So it's not that each FOIA settlement or FOIA judgment is the result of CPD not responding or refusing to comply. It's how the FOIA statute is set up that the prevailing party is entitled to attorney's fees. And that could literally come down to a court deciding that we improperly held one document, not a warehouse worth of CR files.
You know, Ms. Rodney, that if that is the one document that is the quote unquote the smoking gun, then, and the city has been liable for doing that. The law department has been caught by the courts withholding key evidence in cases. So it is not unreasonable to assume that they would do it again, although we hope they would not. It's not an unreasonable assumption. I just think that the city has to do better. We have to come up with something, and I don't understand. If you're talking about, well, we might be paying $8 million in production fees and the cost to produce these documents, we might be paying it $8 million in settlement fees if they walk away. So, it's still the same. We're still not really dealing with the issue. I think what the court suggested in this case, where they roll, the documents out and they have a time period, I think we need to put that in place, and we need to put that in place now. And so, if we were to hold this, we know that the appellate court will meet in the fall. And, their opinions will be issued soon thereafter. So assuming we don't meet in August, if we could hold this until September, I think you'd have a council that has done something really, I want to not say admirable, but actually we have actually advocated in the public's interest. And I think that's more important than getting this done today. Thank you, Mr. Chair.
Thank you. Alderman King?
Yeah, thank you, Chairman. Just following up on Vice Chair Hairston's comments, which I agree with wholeheartedly. I think we're, are we missing an opportunity for transparency? I just like a follow-up question to that end, because I get the burdensome question. I just want to avoid it being used as an opportunity to block transparency. And to that end, did the city seek to propose a settlement that would both require CPD to release the data completely, but in a way that wasn't burdensome? So as we proposed and went back and forth with, proposals, could one be, how fast we release the data or how fast the data comes out, as opposed to not getting the data at all?
Well, settlement negotiations are confidential, so I can't speak to them on the record, but I can just, as I had said earlier, there was no attempt to ever narrow the request by Mr. Green so it could be less burdensome. And while we're on the topic of burdensomeness, I know Alderman Hopkins had asked about the standard for that. So I did get a little bit more information. It may also go to your question as well, Alderman King. But burdensome is weighed by balancing the amount of time necessary to complete a request against the public interest in the materials requested. And it's usually considered burdensome if the request cannot be responded to in the 10 business day deadline provided by FOIA. So there are legal cases that say 7,000 to 9,000 pages of documents are considered burdensome. And in the law department, we train FOIA officers that, there's no magic number, but if a project takes approximately over 40 hours, that could be an argument for burdensome. But that claim has also been rejected by court. So it's dealt with on a case-by-case basis. Just in that 4-year period that CPD is currently working to disclose, there are over 30,000 CR files, and each file can consist of approximately 100 pages. So a request for 44 years worth of records, approximately at the time it was requested, is arguably burdensome because, like I said, CPD is projecting 10 years to comply with that request. So that's not certainly something that could be responded to within 10 business days. So the amount of time it takes to comply with the request is something that is considered in the burdensome analysis. But so no, it's not something that's raised to block transparency. It's raised to a signal that we cannot comply with this request within the time allotted by FOIA. And what some requesters will do is they will then narrow their request so in a way that can be responded to in the time allotted. And I mean, it was a litigation strategy by Mr. Green that I can't speak to, but there was never a narrowing of the request in a way that CPD could respond to. The 4-year period was set by the court, so the parties then worked on a timeline for complying with that, which is by the end of this calendar year.
Sure, but the burdensome cap, if you will, was blown by, this particular case. So I guess what I'm saying is part of the settlement, because it seems what we're asking today is let's settle this case, but then we may close a window, an opportunity for more transparency without another trial or another person suing the city. So my question, I guess, is could you have said, we'll settle in this case, and instead of, getting all the data in this narrow piece of time, this longer piece of time would be better for the city and less burdensome? Could the city have said that?
It's possible we could have said it. I do not know if it was said, but there were attempts to narrow the request that were just not agreed to. So, right, narrowing versus setting a time period, I recognize those are two different things, but, excuse me, with the exception of this proposed settlement of 500,000, there was not another proposal to say, okay, well, let's limit it to records from the last 20 years, and that was rejected. So we're still left with the request on its face for all CR records. But I don't want this body to think that settlement of this case then means that the city is saying to the public, we don't think you're ever entitled to these records, and we're just going to move on to the next issue. Excuse me, my phone keeps ringing. But we are working on ways to make the information, the appropriate information, available. I mean, there are a lot of factors we have to take into consideration. Availability of records, what the CBA allows for, and what's the best time period to start with. So all of those things are under consideration. This isn't going, the settlement will end the litigation, but will certainly not end the city's work in figuring out how to make these records available to the public without having to go through FOIA or litigation.
But will it send the city's obligation to by court order?
I'm sorry, will it?
But will it end the city's obligation to by court order?
Right, part of the settlement includes the parties moving the circuit court to vacate the order to disclose all these files as part of the litigation, yes.
And so any subsequent cases, if you will, would be subject to the burdensome clause, let's just say, that all the other cases that predated this were subject to.
Well, I don't want to completely speculate, but if I would argue that a FOIA request for 40 plus years worth of records is something that CPD cannot comply with within 10 days, and likely a burdensome objection would be raised. And then a party requesting might consider narrowing their request. There is some back and forth that goes on with FOIA requests. It depends on the requester and what they're looking for. But I said there's nothing stopping anyone from saying, I want Officer Smith's closed CR files during his entire tenure with the CPD from 1990 to 2000, for example. People can continue to submit those requests and they will continue to be evaluated.
Right.
So nothing stops that.
And who would evaluate? Who determines?
So that would, if it were CPD that was being requested, so if it's a CR file, of course it would be CPD. Their FOIA officer reviews it. It's re-reviewed by a sergeant. And so they have a whole FOIA unit dedicated to reviewing and responding to FOIA requests. And that unit meets with the law department on a weekly basis to review all of their requests and their responses.
Okay. So the difference in this case in those would be that a court has decided that the burdensome argument isn't effective here or isn't applicable. And in the other cases, CPD would decide what's burdensome and what's not.
Right. So a FOIA request comes in and it goes to the department to review and to respond to. If the requester is unsatisfied with the request or they don't get a response, sometimes they will turn to litigation and have a court decide whether the response was appropriate. In this particular case, because CPD did not respond at all, when it later tried to raise a burdensome argument during the litigation, the court pointed to the lack of response initially. So I don't believe there was even an analysis by the lower court into burdensomeness. They did not hear the city's argument because they considered the city having waived that argument by not responding to the request in the first place. So those improvements in the FOIA process should avoid that problem going forward, since now the FOIA unit at CPD is subject to a number of quality control measures where responses are always made, appropriate objections or exemptions are always raised. So to the extent it reaches litigation, we have that to fall back on. But ideally, it won't, but we can't control who sues us, but we can certainly control how we're able to respond in litigation.
Okay. I know my colleagues have other questions, but I guess one last question is, if we, voted no on this settlement, or if we decided to defer it, as Vice Chair Hairston suggested, could you then go back and settle the case, or enter into a discussion about settling the case with perhaps amended rollout of all the CR requests over a period of time that wouldn't be as burdensome as you guys are suggesting this is, and I believe it is, certainly.
Well, if the settlement was not approved, the current appeal is underway. The city filed its opening brief last week, and I went through the timeline in answering Alderman Taliaferro's question. So that litigation, the appellate litigation, would proceed for the next few months, and then the parties would wait for the court's ruling. I mean, I can't speak for plaintiff's counsel as for any future attempts to settle the matter, but plaintiff's counsel would have to come to the table if they were interested in that. But if we postpone the matter, we leave it up to the appellate court, who then would decide either the circuit court order stands and CPD, you are required to produce these records over the next 10 years at whatever the cost and resource allocation would be, or they would say, circuit court, you got it wrong, hear out the city's arguments as to burdensomeness, and we would wait for the circuit court to act per the appellate court's order. So in that scenario, if the city prevailed in the appellate litigation and it was sent back, one of the possible outcomes is that we would not be under the requirement to produce 44 years worth of records. Also, Mr. Green would not receive any money in that instance.
And just to clarify, it's 44 years over 10 years?
Right. To complete that project, CPD is estimating approximately 10 years at a cost of $8 million to identify, scan, review, redact, and produce records from 1967 to 2011.
And the city considers that the 10-year period burdensome?
Yes.
Okay. I just hope we don't miss an opportunity to be more transparent. 10 years for a lot of documents. I mean, I can't sit here and crunch the numbers. It doesn't sound burdensome off the top of my head, but like I said, I don't know how many documents it is, but I just don't want us to miss an opportunity that might be closed if this case is settled. So I will allow my colleagues to ask questions, more questions. Thank you, Chairman.
I missed that. Alderman Patrick Thompson.
Thank you, Chair. Just a couple questions. I know to piggyback on what my colleague was just saying. So how many FOIA requests does CPD get each year?
I don't know, but I think we can try to get a fairly quick answer, but it is robust. Just from what I see in the weekly FOIA meetings, they certainly get FOIA requests on a weekly basis. So there's rarely a lull in activity, and those requests aren't confined to CRs. They cover a broad array of issues, but I mean, CPD, some smaller departments may have one FOIA officer. CPD has a FOIA unit with both sworn and civilian personnel. So I think that speaks to the volume of requests that they receive. I'll see if we can find out how much.
Yeah. So, and then how many FOIA requests do we get, the city, other than CPD?
Again, based on what I see on a weekly basis, dozens of requests across the city departments and sister agencies.
And all of those sister agencies all come through the corporation council, correct?
To the extent there is litigation, yes. I will say for the city departments, for departments such as CPS and CTA, I don't believe that we handle their requests, any litigation, but for the city departments, yes.
Okay, CTA is not a department, it's a separate government. CPD is a department just like streets and sand and just like water and every other department. So
Yeah.
we have the jurisdiction over that, not the CTA though. So if a FOIA request comes in for AIS or for water, does it just go to their department, or do you have, if it's litigation, or does it come to you?
Each department is required to have their own FOIA officer. So the department's assigned FOIA officer is responsible for reviewing and gathering documents to the request. The city departments keep in touch with one another as to what the various requests are, so we can know what's being requested and how it's being responded to across departments. If a city department gets sued based on their response or objection, that is litigation that comes to the law department to handle.
But not the FOIA request per se.
No, but our FOIA attorneys collaborate often with other city departments who may have questions about how to respond to a request, whether an exemption is appropriate. They do consult with the law department.
And have we had any other, do we have any other issues or delays, lawsuits pending for FOIA requests in other departments like we have with CPD?
Well, I just found out CPD receives approximately 13,000 FOIA requests per year, which is probably the highest. I don't know for sure, but I think just based on numbers, CPD may be likely to have more litigation than other departments, but it's certainly not the only department where we've had FOIA litigation surrounding their response.
Yeah. Well, I think that's something that I think the Corp Counsel's office can take a look at to see how we can set up for all departments, not just CPD, but all departments, to make sure that we're responding quickly, obviously with modern technology. The other question I just had is, I know we're talking about going back to the 60s and these older records, which makes it a little bit more challenging. And I just know from the court system, if they're older, then they're on the microfiche and they're old and you've got to manually go through documents and whatnot. But under the collective bargaining agreement for the police, those records are supposed to be destroyed after 5 years or 7 years. So do we know if these records exist? I mean, part of the problem is if we're looking for something that we don't even know if it exists, like if they say Officer X, and you have to look through files, but aren't after 5 years after the incident. And I know we perhaps haven't destroyed them pursuant to the collective bargaining agreement, but if we did, are we looking for something that doesn't exist sometimes?
I need to get clarity as to certainly arguments have been made by certain unions that records should be destroyed after a certain time period. Whether that argument was upheld by a court, I don't know. I think it conflicts with the city's obligation to retain records.
Well, I'm looking at section 8.4 of the collective bargaining agreement.
Okay.
It's not a legal argument. It's a contractual obligation we have under the collective bargaining agreement. And so I guess when I was looking at that, I'm thinking perhaps people are looking for files that don't even exist because they were destroyed, or I don't know. I mean, I think, and you know what, and maybe this is something, Chair, we have a discussion, because I don't think you'll be able to answer this right now. But I do think that we need to have a comprehensive look at this, and I would say the Corp Counsel office would probably be the best to do an evaluation of all of the departments, because CPD is just a department like every other department that we have. We want to make sure what we do and what works in water works in every other CPD or the fire department or whoever it might be, giving understanding that CPD has the largest volume, but to make sure we have a system in place. And my final question, and perhaps this
Alderman, to that point, we could have a subject matter hearing to discuss all of the different agencies and committee structures and departments and how they operate under FOIA. We could put that together.
And I just don't know offhand, because I'm still I don't know, but if the consent decree requires anything, obviously we're going to have the obligation to make sure we get that done, and should do that in conjunction with, as all the reforms that we've already started in the police department and in the city that we're doing, we should do that in conjunction therewith. So, maybe Chair, I could talk to you offline. We could do something separate from this, but I appreciate it. Thank you.
Point of information.
Yes, Alderman Curtis.
Yeah, this is just a statement, and I actually believe, and I've given this a lot of thought, I actually believe that whoever filed this actual FOIA complaint assistant, Mr. Green, knew that the police could not get this information, get the FOIA, and that's the reason why we're at the position where we are. So just like my colleague, Alderman Thompson said, we just have to fix this so it'll never happen again. Thanks.
Thank you, Alderman. Alderman Urban.
Thank you. Thank you, Mr. Chairman. Two things. One, and help me break this down. We have a financial issue as it relates to settling a lawsuit that's currently before us. And second, we have a question regarding the ongoing or the ability for us to put out the information that's being requested. One question that wasn't answered on the latter is the information even available?
As far as the 4 years worth of records or going back to 1967?
Going back, what's actually there? Is that something that, are you able to let us know?
I can't say. I mean, FOIA requires a reasonable search of records, but I believe there are, several 100,000 worth, files in warehouses, right? So the warehouses would have to be searched for the records. So, I mean, I don't want to give off the impression that because these records are old, they're not there. It's possible some have been destroyed. I just don't know. But if we were to comply with the court's order, a search would have to be done for all files in existence going back to 1967, and then we would produce and redact what was available.
So we have not done that to date.
Well, I mean, CPD is certainly aware of this pending court order, so they began assessing what it would take to produce that, and that's how they came up with the 10-year estimate, the $8 million expense. So, right, I'm sure CPD has a sense of the volume that's available.
Okay. So as it relates to settling a lawsuit, you're asking us to settle this particular case for the $500,000, which is inclusive of all fees and everything. Is that correct?
Yes.
Okay. The risk of us not settling the case is what?
Is waiting to see what the appellate court decides, as far as our appeal of the circuit court's order. So if we do not prevail in the appellate court, the circuit court order stands unless we sought relief to the Illinois Supreme Court. And I can't say if that'll happen, but that's
Point
an
of
option.
information. Point of information. We do not.
Vice Chair.
Thank you. We can settle before the appellate court renders its decision. Is that not correct? Is that correct?
Well, that's what we're trying to do today. I'm
But
saying if it's not approved today, I can't
that you
guarantee that
said
plaintiffs.
was that we would have to wait until the appellate court rendered its decision. And that is incorrect.
Well, I thought the question was what was the ramifications of not settling today? It was that the appellate litigation would continue. And I can't speak for whether plaintiffs' counsel would be interested in postponing a settlement or re-engaging in settlements at a later time.
Okay, but your statement to Alderman Irving was that if we did not settle today, we would have to wait until the appellate court rendered its decision.
Well, the appeal is ongoing, so the appeal will proceed in the natural course.
Well,
Yeah.
my point of information is that we don't have to wait until the appellate court renders its decision. A settlement can be reached at any time.
To the extent the other side is willing to engage in negotiations, yes.
Thank you.
Thank you. Alderman Urban.
Yes.
Alderman Urban, you're still got the floor
Yes.
there. And then Alderman Dell.
Excuse me, I didn't hear you.
I had a
Point of information from Alderman Dowell, but Alderman Urban, you still have the floor once she makes the point of information.
I just want to clear based on Alderman Hairston's question that is it possible to separate out what Mr. Green is asking for to the question on from the question on the these reports, the transparency of these existing outstanding CSR reports, CR reports. That's my question, point of information.
I don't
Renee,
think so. I don't think so. I mean, Mr. Green has decided through his attorney that he is willing to settle the case in this manner. I mean, perhaps it's not a good enough answer that the administration is working on this. And, I apologize for not having a complete policy for this meeting about settlements, but I can assure you that the city is thinking of and committed to coming up with ways as to how these records can be made available to the public. And, that may mean, not producing 44 years worth of records at one time, since that would take 10 years, but seeing what's a reasonable number to be able to make available, in the next 6 months, for example. I can't speak for the administration in that level of detail, but as I'll just say it again, there was never an agreement to narrow the request with Mr. Green, but the parties were able to reach this settlement. So if it's not really a matter, like, unfortunately, the body cannot direct Mr. Green to settle this case in another way. I mean, if you don't approve the settlement, the appellate litigation will continue. And I mean, to the extent the city wanted to try to engage in some other settlement, Mr. Green's attorney would have to come to the table for that, but there's certainly no guarantee.
Yeah. Alderman Urban.
Thank you.
I'm sorry, we got cut you off there, but go ahead, Alderman Urban.
Okay, no, we're all here. So what additional financial exposure exists from not settling this case today?
Losing in the appellate court and CPD having to produce the CRs at a cost of approximately $8 million over the next 10 years.
So let's say this for the sake of argument, it sounds like as a group, for the sake of transparency, we would like to enter into a point where we produce the record. So I don't want to use the $8 million as part of that conversation. I'm specifically speaking to losing in the next round, what is our financial exposure? Because I believe that, and for the sake of transparency, we want to produce the records. We may not want to produce them the way he wants them produced, but we do as a body seem to want those records produced. So my question is about the specific financial liability of this particular settlement.
If the settlement is not approved and we lose in the appellate court, we'll have to pay Mr. Green's attorney's fees, in addition to any other expense associated with producing the CRs under the lower court's order.
So are we talking another $500,000, $1 million, $5 million? What do you? I don't know what his fees are today.
Right, I'd say estimate about 1/3 of 500,000. So approximately, I don't have a calculator, but it would be 6 figures in attorney's fees that we would have to pay if we did not prevail.
So we're talking what, another $160,000?
Probably between 200 and 250,000, but he would incur fees by doing the appellate litigation. So that would be additional fees, which I can't calculate at this time.
Okay. So your position, and correct me if I'm wrong, is that we end this particular piece of litigation and then come back for a discussion on how to disseminate how many ever years do we think makes sense to produce of records for CPD CR numbers.
Right, that's an effort that CPD and the city can undertake outside of the confines of the litigation and in a way that ensures the information that the public is most interested in, which arguably is not an alleged traffic violation of a cop in 1970, but perhaps, some substantiated claims of misconduct more recently, how to produce that information in an expedient fashion. So yes, that's something that can be done outside the confines of the litigation if the settlement is approved.
As part of this endeavor, could we as a body approve the settlement order, but also approve the release of certain records for a certain time period that we deem to be appropriate for certain types of CR cases, notwithstanding the traffic violation of 1970 type of action?
I don't know if that's something that would be binding, but to the extent that you all wanted briefings or hearings, I think we'd certainly be open to that. I don't know what mechanism as far as like an ordinance or anything could be.
Renee, and Alderman Urban, I think we want to approve this because we've advanced it as far as possible. I don't think we can then separate the two in the settlement, but I think your point is well taken. And as a body, we should be working on legislation to make all of this information public. And as I mentioned early on, we could do it through legislation that requires the information to be put on the OIG portal. I mean, if you look at the OIG, they already have years of information out there. So I think working with you and others, we could draft legislation to do exactly what everybody wants, which is the objective of transparency here.
Okay, well, I would agree with that. I do want us to stop the hemorrhaging financially for this case, but we do also want the transparency that I think that our citizens and everyone is asking for. So if that's the way that most efficiently that we can do this, then I would definitely be in support of doing that, while at the same time stopping the hemorrhaging from this particular case, so that we can, move forward and get the information out in a way that really is helpful to our citizenry here in Chicago. Thank you.
Absolutely, yes. Alderman Haddon. Thank you, Alderman Urban. Alderman Haddon.
Thank you, Chairman. I want to urge my colleagues who sit on this committee and the others who, like me, will have to look at this in council on Wednesday to kind of reflect on this moment and consider either delaying making a decision on this or rejecting the settlement. I appreciated the logic laid out by Alderman Burke on the legal strategy. Really appreciated Vice Chair Hairston's comments on just the historical context that we're in, the history of not just the department, because I would also go to Alderman Thompson's point of the Chicago Department of Police is part of the city. Our city has some bills due, you guys. It's time to pay the piper. So we can do this one way or the other. We can continue paying out settlements. And in this particular instance, I think symbolically agreeing to this settlement, paying us $500,000 and deciding that we're not going to do the release of the records. We don't have a plan. Council, I know you've said that supposedly the city is working on a plan. I haven't heard of any plan from the administration on these records. If one exists, then Chair, I look forward to getting more information on that. But what I hear is an estimated cost from the department of $8 million over 10 years, which seems a small price to pay for us to come up with take the steps towards accountability and transparency that we need. So we can pay this in one way or the other. We can name the tune that we're going to play. Our residents, our city is looking to us to take proactive steps for reform and transparency. We could not settle. We could create the structures and put the money in the budget for making these documents available. And we can do so in a way that makes sure that it's easy to answer FOIA requests, that people maybe don't have to submit the FOIA request. And I hear the general sentiment and appreciate Alderman Irvin's comments and Alderman King's comments. I think a lot of people do want the transparency and the accountability. However, doing this in an efficient way or to expediency or because we're trying to make this not as painful, frankly, from the outside, this looks like, if we pay the settlement, it looks like hush money. Like, oh, we can't come up with the records. One of our departments screwed up to begin with. Let's just pay off this settlement so we don't have to face the reality that we have a history of opacity, of corruption, of not taking the public seriously. And I don't know if you all realize the moment that we're in, but this is not the time to take the same path as usual. This is the time for us to make a stand for accountability and transparency. We can do so in this decision. Whether you just think it might be prudent to delay and wait to see what comes out of the appellate process, whether you think it's prudent to delay and reconsider this the next time you convene, or whether, like I would urge you to do, you reject this settlement and look towards coming up with a real plan to satisfy this request and to satisfy this order. The city of Chicago needs to do what's right and to stop taking the shortcuts and keep saying, oh, we'll get around to that. People no longer respect that. People no longer respect our body. They're not respecting authority. And if we're going to do the hard work of regaining the trust, of regaining the respect, if you want to see law and order restored, we've got to take strong, bold actions to demonstrate to the people of Chicago that we are doing what we are supposed to do and that we're going to pay the consequences of inactions, even if it wasn't you who did it. So I would urge folks to really reconsider that. And I know our council, they come to us with recommendations that might be based purely on the financial piece. But we need to think as council members beyond the financial impact of this and what the short-term and long-term needs of our city are. So thank you.
Thank you. Alderman Smith and then Alderman Vasquez.
Alderman, Chairman, I just had an answer to a question that came up earlier.
Okay, Ms. Rodney, go ahead.
Pardon the interruption about, do we know if these files exist? The $8 million estimate reached by CPD was based on actual files identified. So it's not based on an assumption that files exist, but it's based on files identified going back to 1967. So just wanted to add that. Thank you.
Thank you, Alderman Smith.
Oh, I guess I'm getting called on because Alderman Vasquez is not on the committee because I saw his hand up first.
You're next, and then Alderman Martin.
Oh, okay. So I guess I agree with an awful lot of, I'm not guessing, I do agree with a lot of the comments made about the lack of transparency of our city government with regard to FOIA. And this is a problem that's been going on for a long time. And I'm also agreeing with the comments that, especially right now, in an area where we are trying to get our arms around and are pushing very hard on these issues of police accountability, that this case is very, very unfortunate. Where I don't agree, and I'm just saying as a lawyer, I don't agree that it means that we should not settle a case with a particular plaintiff. If this city council wants the city to get a move on accumulating, cataloging, and preserving and publicizing our records of police misconduct, we can do that all by ourselves. And I will certainly join any effort to make that an order, a priority for our next administration. All that delaying a police settlement does is increase cost to a city that is reeling in the middle of a financial problem right now due to COVID, decades and decades and decades of financial issues, pension issues, horrible police settlements. You know, we're right now in the fulcrum of making the change. This is the crucible. So we are in the point where it's expensive to make the changes and expensive to pay for our past mistakes. And I don't see why we should make it even more expensive by not settling on a case with a plaintiff who has an actual person, plaintiff, who, for whatever reason, his personal reason is that he'd rather have the money. I mean, that is the way it is. So while I, again, agree, we need to get a move on. Let's order something to be done. Let's introduce something in September or whenever the next time we can. Let's get a plan together. But I don't see any reason to delay a settlement for that reason. So, you know, I intend to vote for this, being a strong supporter of government transparency, reform, ethics, police accountability. But I don't see any reason to delay paying this settlement so we can attend to the business at hand. Thank you, Mr. Chairman.
Thank you. Alderman Vasquez, I had skipped over Alderman Dowell. So Alderman Dowell, did you have your point and then come back to?
Yeah, thank you, Mr. Chairman. I have a couple of questions. First of all, I just want to say to Maria, Alderman Hatton, thank you very much for your impassioned plea, which is the right plea. And I just wanted to acknowledge that. To Ms. Rodney, in your summary, you mentioned the Invisible Institute. Can you tell me what role they play with this case or with the law department?
Yes, Alderman Dow. On their website, the Invisible Institute says that it is enabling their capabilities to add to what they describe as a growing library of 230,000 plus pages of complaint documents that are being released through the Green versus Chicago lawsuit. And from there, they'll be creating tools to explore dimensions of what they call misconduct data through their partnership with Northwestern University. So it's our understanding that the 4 years worth of records that are currently being produced in the Green case to Mr. Green's attorney are being shared with the Invisible Institute, and that the Invisible Institute will be publicizing that information through their website or their partnership with other entities. They are
Okay,
not
have
a
they-
party to the case, though.
They're not a part of the case, okay, but have they had any discussions with the law department in terms of the sharing of the remaining cases that they want to see become public? Are they requesting that information from the law department?
Not that I'm aware of, no.
Okay, so the Invisible Institute has had law department on this matter at all.
I'm sorry, you broke up a little bit there.
Alderman Dow, we couldn't hear you there. You broke up a little. If you could repeat the
Oh,
question.
I was asking if the Urban Institute, if the Invisible Institute, I just want her to confirm, has not had any kind of ongoing discussion with the law department about how these reports should be released, timing, number, or anything.
In the context of the Green litigation, no, I don't believe so. We've only been dealing with Mr. Green's attorney.
Maybe not in the context of the Green litigation. I'm just asking in general.
I do not know.
Okay. And my other question is, have you given any thought to going back to the plaintiff's attorney to see if we might be able to bifurcate the issues here so that Mr. Green can get his payment? And we could deal with the transparency of these remaining records.
Before this meeting, no.
Have you given that any thought? Is
I
that
can
a
take,
potential? Is that a potential strategy?
well, as it stands right now, I don't present anything to this body unless we have a signed settlement agreement with the parties. So under the terms of the signed settlement agreement, that is not contemplated. If the settlement was not approved, then there would be no settlement agreement to present to the court, since this is above $100,000. And it would be, figuratively speaking, back to the drawing board if the settlement was not approved and while the appellate litigation was underway.
All right. Thank you, Mr. Chair.
Alderman Vasquez.
Thank you, Chairman. I really appreciate the discussion. I am with my colleagues asking for either a delay or a no vote on this, but I've got a couple of questions. And I just want to say first, to something that one of my colleagues said, it's not that the public wants the documents and information. The public has wanted them. So this isn't a singular ask. It's not a recent ask. And so to kind of say that, hey, we're going to start working on it, when this is something that many of us who got elected to come into the council were advocating for as far as getting this information, I just want to make sure that we frame it that way. And that when we think about, it's not just the transparency, it's also the accountability. Because in this case, what makes it different from the other requests for it is the CPD is able to say it's too burdensome, so we can't do it. And there's not a threshold. So the fact that there is a court order to do so provides accountability we couldn't provide ourselves. But I want to focus on the financials, because I know everyone's kind of thinking through us saving, I guess, the $8 million for something that we should be doing anyway for $500,000 in a settlement. So my question is, do we have a number of how much we spent in settlements over the last 10 years? I know it's over 600 million, but I don't know if we have a definite number.
Well, all of that information should be available on the law department's website. To the extent it's not, that information can be made available. I do not have a number off the top of my head right now, but that information is made available to the public.
Yeah, I mean, that's why I know it's north of 600 compared to 8 million that we're talking over a decade. We know the cost of the police budget is 1.8 billion compared to 8 million we're talking over 10 years just to provide transparency. How much is spent by the CPD's FOIA department annually?
I don't know.
Okay, how about how many of those positions are civilian compared to officers?
I don't know, but I can try to find out.
Okay.
Alderman, I think that's available in the budget book, and if it's not, we can ask CPD, but I don't think she would have that on hand.
Yeah, I just want for the record, because we're making it seem like 8 million is an exorbitant amount when we spent hundreds times more because we don't have that information. We're not looking at it. We're not looking at records as to that might set up patterns as to who has complaints, what kind of complaints they are. We take people at their word, but we won't provide it in a transparent means digital. And we have the paper records to do so, but we're not taking the endeavor. And the closest I've heard, and my colleagues have heard, is on this hearing saying, oh, we're thinking of doing a process, which is something that we hear about everything, including the Columbus statute this weekend. Everything's a task force, everything's a working group, everything's something in the process. We're never informed of it. And I don't think that the public needs to have that kind of faith in something that hasn't proven results. So and I know everyone keeps asking the question about bifurcating, but this is, for clarification, it's pretty simple, right? Like the plaintiff wants all these records and the city is saying, we don't think we can do it, want to do it, will do it, but we would rather pay the settlement money of $500,000 than to actually complete what's being asked for, which is full transparency of all these records. We have an Invisible Institute that is willing to take those records, make them more accessible to the public. So ultimately, it's not an either or. You can't bifurcate the two because that is the nature of the settlement. It's either the $500,000 not to do the work or not pay the money and then do what's required. Is there something I'm not understanding here? Because I know everyone's asking the same question.
Well, I mean, if we prevail on the litigation in the appellate court, and it goes back to the circuit court, there's a possibility the circuit court would have to hear our arguments regarding burdensomeness. But that does not mean that the city can't undergo its own efforts outside of the litigation to make these records available.
Right, but have there been attempts to do so in the past prior to this case as far as all the backlog of records?
Do you mean outside of it being requested in FOIA or being routinely released in litigation?
Saying, understanding like with other city documents, we have a ton of stuff that's on paper. It makes sense just to make it digital and make it easier to access for people. Has there been any effort, any endeavor or conversation in doing that just for sake of transparency and accountability?
Yeah, there's certainly been conversations about it. And I know that's not satisfactory to folks, but I'm not going to lie to you and say we have a plan fully formed and we're just waiting for the right time to announce it.
Right.
The administration recognizes the desire for transparency, and settling this case would allow us to continue in that direction of figuring out how to best release these records, while that $8 million could be diverted to other resources such as violence prevention or mental health resources. So
in that case, the $8 million that we directed to those efforts would negate any process to really get, here's what I'm saying. If there's a commitment to get these documents produced, that has a cost no matter what or who's asking for it, right? Like there's still, to do those records, what the cost of $8 million is to do those records, independent of any settlement or lawyer fees. It is to do the process. So if you're saying the city has a commitment to do it, or we're thinking about doing, we have a plan, that's still going to be the same cost for something like that, unless, to your point, you narrow it down and you don't provide all of the records.
It could certainly be a different cost. And I think it's a valid question to ask if records for officers who are long deceased or have, unsustained findings of misconduct that are over 30 years old is in the public interest. I don't know the answer to that question, but it's a question worth asking. So I think in figuring out those answers, we would necessarily narrow the request. And I mean, I can't commit to anything on behalf of the administration, but that might involve, talking to community members and organizations that have an interest in these records, where we say, for example, we have all of these records that are digitized that can be produced in this kind of way, but the further you go back, once we get to hard copy records, that might be harder and take a longer time to produce. So in those conversations, we can figure out a way how to get things out. And yes, certainly there would be a cost. I don't know what a comparative cost is right now. We just have the cost of complying with the court's order as it currently stands.
Right. So I think what I appreciate about what you said, which I think is really representative, is there can't be a commitment made, but in effect, that's what the case in the order is a commitment to do it. Just we didn't commit to it as a city, right? So for that reason, among many stated by my colleagues here, I would recommend and urge my colleagues to vote no or to defer this, and that our members of the council, should this come out of committee and reach the council, similarly vote no as a commitment that we want to go through with it based on the order, because people just can't take us at our word when we have not delivered and just come up with other task forces, commissions, groups, polls, focus groups, surveys, instead of just doing what the people want, which is provide the records. Thank you very much.
I mean, if I could just respond.
Alderman Moore.
Oh, sorry. Go ahead, Chairman.
Alderman Moore.
Thank you, Chairman. Just real quick, Renee, because I think I heard it, but I just want to be clear. You don't have to go into a whole bunch of detail. A couple of simple questions. One, so the court ordered us to produce the records, yes or no, in their order before the settlement piece?
Yes.
And who then asked for the settlement? Did the plaintiff ask for the settlement, or did we introduce the settlement to the plaintiff? The financial settlement.
I mean, we've been in ongoing conversation with plaintiff's counsel as to how to respond to his requests in a way that's less burdensome. And I mean, I think with most litigation, financial demands are made by the person bringing the litigation. And then the defendant, which in this case is the CPD, decides if it wants to respond to those demands. So from those conversations, that's where the parties reached the $500,000 settlement.
So I want to be clear, the financial part was introduced by plaintiff, not the city, yes or no?
Yes.
Okay, thank you.
And I just found out for Alderman Vasquez's question about the makeup of CPD's FOIA unit. There are 18 civilian members and 7 sworn. And of those 7, there are 5 FOIA officers and 2 sergeants who manage the unit.
Thank you for that.
Vice Chair Hairston. Alderman Hairston.
Yeah, no, I was trying to unmute. I just have a point of information to Alderman Dow's question that in the lawsuit of Calvin versus the city of Chicago, the court ruled that CRs were public information. And so I think that would be the context in which the Invisible Institute has a relationship with the law department.
Thank you. Alderman Urban and
Thank you,
Alderman
Alderman
Martin.
Hairston, for that information. Appreciate it.
Alderman Urban and then Alderman Martin.
You know what? Never mind. I was David Moore's question I had raised because she hadn't answered it, but she did answer it too. Who brought the financial settlement forward in that case when it wasn't the city?
Okay. Alderman Martin.
Thank you, Chair. I wanted to underscore some of the comments that Vice Chair Hairston had made in terms of transparency, as well as our willingness and our ability to pause for a few weeks or a few months to get greater clarity, because I think it's not a decision in terms of approving the settlement that captures the sort of transparency that is badly needed here. And while completely respecting Alderman Smith's point about our ability as a city government to step in and act unilaterally, I think we're developing that muscle memory. Obviously, we had several decades of experience of not doing that which precipitated the consent decree, among other real, I think, scathing indictments of our city's government's inability to step in and do the right thing here. I also have concerns around the fact that there's a plan that's maybe being discussed underway in some degree in terms of what some sort of, I guess, publication by the city of these records would look like. Is this something that would be 100% of what the plaintiff is seeking here? Almost certainly not. Are we talking about just 5 years, 10 years? Is it a reduced scope? I think these are the sorts of things that are really important, especially when we're comparing that against that $8 million figure. Will we ultimately spend 7 million, 6 million, 5 million? I think those are the sorts of questions that we need to answer here, as well as see what the outcome is, if not see what some of the next steps are in terms of this litigation moving forward. Because I think it also sends an important signal internally, as well as to the public more generally, that we will take incidents of like less than adequate conduct, let's say, in terms of how this FOIA was responded to. Because when we're balancing the burden here with the public interest, this is a unique situation, and it would, in my opinion, result in a unique balancing of the interests. We're talking about many, many, many decades of rampant systemic abuse, misconduct that occurred within CPD and the broader city government. We know that over that 5-year period, 2011 to 2015, that is, Alderman King noted, kind of blows our typical arguments kind of out of the water. So we need to look at this in a unique way. I just would really hope that we can at the very least slow down and look at these different points of consideration, because it's going to be, I think, more challenging for us to move forward with figuring out what that plan is and having meaningful input once the litigation is behind us, because sadly, it's litigation that's what city government responds to as an entity. So I again would hope that a good number of our colleagues would strongly consider, at the very least, holding this in committee until we can get greater clarity on especially the plan that appears to be underway in some fashion. Thank you.
Chairman, it's Alderman Riley.
Go ahead, Alderman Riley.
Thank you, Chairman. I just wanted to clarify a couple of points before we vote on this. That the plaintiff has willingly entered into this settlement with the city of Chicago, and the plaintiff apparently wouldn't do that if he weren't satisfied with the terms. Is that correct?
That is correct. We currently have a signed settlement agreement with the plaintiff.
And also, just so I'm clear, the original purpose of the record request was to support the plaintiff's case that he had been wrongfully prosecuted and imprisoned, right?
I think it's safe to say that is plaintiff's belief, but he was not able to bring a litigation against the city in the context of a reverse conviction case because he was not granted any relief by the state's attorney's conviction integrity unit, which would have provided an avenue for him to seek relief against the city in that way. So I think you can assume that his interest is being compensated for his prior years incarcerated.
Understood. And look, I think there's a lot of merit to members of this committee and the broader city council having a debate and making a decision, frankly, on how we treat these records, both looking backwards and forwards. But I think to delay this settlement and delay this gentleman his financial compensation for these events would be a mistake. We can work together and come to some agreement with the administration on what format those records should be in, where they should be presented, and all of that, while also, I think, shielding the city from a substantial financial cost associated with this particular lawsuit. I think we can accomplish both goals, where this gentleman receives his settlement and the taxpayers gain the transparency they're looking for. I don't know that that's an either or proposition. So anyway, thank you for answering my question. Thanks for your indulgence, Chairman.
Alderman Irvin.
Thank you, Chairman. Alderman Riley, I think you raised a point there. I guess the question is, do we trust ourselves to do the right thing? And that's been a common theme, you know, in a perfect world. I think what you said makes a lot of sense, but this is not just today. This has been a historic pattern of not wanting to give information that predates this administration and even the previous administration. This is just what we do. And if you just want to look at it that way. The question that I would pose in a way to potentially attempt to split the baby is that if we delayed this today, give Corp Counsel and CPD an opportunity to come up with a plan to release records that is then put as part of the judicial settlement, so it would have the force of law, and therefore we would not necessarily, we'd be obligated under law to produce these records in a time that was set forth by the settlement. Would it hurt us to wait until our next meeting, if it's August or September, so that a plan could be put in place and that could be included as part of the settlement?
That depends on what Mr. Green wants to do.
I mean,
Can't say.
I mean, Mr. Green asked for all the records, right? So we can only assume that's what he wants. He's settling for 4 years worth of records and $500,000. Now, again, if we said that we were going to give out records above and beyond the settlement, why would they not be in agreement with that?
The 4 years worth of records is the result of a court order. So the settlement does not address that because that matter has been decided. So Mr. Green has agreed to a $500,000 settlement and vacation of the lower court order ordering CPD to produce records dating back to 1967. So that to date is what his agreement is and what his interest is in. I can't make any representations as to whether he would delay receipt of money for, you know, approximately 3 months or the next time this body met, while the city comes up with a way to release the additional records and that be folded into the settlement. I don't know. I don't know. And I think it's incredibly risky to delay the settlement to find that out if he just decides to walk away and see what the appellate court does.
I guess the question then is a question of timing. If the settlement is delayed, is the appellate court have a ruling in its back pocket that is going to put out tomorrow or Thursday? Or is this something that's where we actually do have some time to make some considerations around this issue? Because it's not as cut and dry as we would like for it to be. There's some greater implications that are going on here. And it's clear that many members of this body don't trust us as a city, and I mean collectively, to put the records out in a timely manner.
Well, the appellate court likely wouldn't hear argument on the case before September, and then they would issue an opinion sometime after that. I don't know. But if the briefing schedule proceeds without any extensions, the briefing could be completed by September, approximately.
Is that September 1st or September 30th?
I don't have the briefing schedule in front of me, but I believe the parties typically have 30 days to respond. So that would be August 13th, approximately, when Mr. Green would have to file a response. he could certainly seek more time if he needed it, but if he doesn't seek any extensions, after he files his response, I believe the city would have approximately 14 days to reply. So that takes us to the end of August, assuming the city doesn't seek any extensions. And then the appellate court could ask for oral argument on the matter. And I'm not familiar with how long it takes to schedule that, but let's just say sometime in the fall, that could happen. And then after they hear argument, we would wait for the appellate court to rule.
Point of information.
Vice Chair Hairston.
Thank you. Isn't it true that the appellate court could reject oral argument and issue a ruling?
That is a possibility as well.
Yes, it is. And the court has it scheduled that they reconvene in September, right?
I don't know.
They do.
Okay.
They do. So currently they are not sitting, but they do reconvene in the fall and decide whether or not they will take a case or whether they won't. And if they decide not to take that case, then they will issue a ruling and the opinion of the circuit court will stand.
Alderman Irvin, were you done with your questions?
Yeah, I'm done. I really, this puts us in a very unique position. While I do tend to want to get the financial matter out of the way, we do have a much larger question to deal with. And if there's any way, we need to introduce some legislation, preferably on Wednesday, to begin to address this issue. We can't continue, just pause. We have to give our people a real sense of getting some finality to this. So, if it's possible, I know we have that today, we'll pass our general deadline to send stuff for introduction, but I believe that it would be in our best interest to introduce some legislation on Wednesday to address this issue and to move this ball forward, because this is just not right how we're ultimately handling the request part of this. The financial part is a separate issue. So if we could do that, I'll be glad to sign on to such an effort, and I think many members of the council would do that as well. We need to do something beyond what is happening right now. Thank you.
Okay, let me speak to this before I go back to the final two people there. The objective here is to have transparency, and we've reached this point where we realize that the police department for decades was not doing the correct thing, especially in terms of FOIA. So the objective here is to get transparency, not just through CPD, but every one of our agencies. This can be done through legislation, and as I mentioned earlier, I would like to draft legislation, whether it's an order or an ordinance, that basically says to put this information out there for serving the public interest, but protecting those who perhaps might have testified or have information within those files. If you give those files to the outside not-for-profit or through the lawyers, that information just goes out there, and we don't have control over that information once it's fully out there unless it's very well vetted by CPD. If we give the information as we have suggested that the Office of the Inspector General should have, with the amount of data that they've been putting on their portal, and I think a lot of you have seen the information portal and understand what kind of things are going up there, that is, to me, one of the best places to put the information up. If you look at what's up there right now, you have investigatory stop reports, you have tactical response reports, you have complaints and notifications and the arrests. And I think that the Inspector General could work through that data. We're talking about HIPAA information. We're talking about putting people's private lives potentially at risk with that information just going out. And we're talking at probably over 170,000 files. If we give it to the OIG through legislation, if we say to the administration, here is what we're going to do. Here's where the council wants this information to go. It's already active, it's already user-friendly, and it becomes publicly validated through the OIG. So it's my intention to move forward on a vote, but at the same time, push to get the administration and CPD to provide that information publicly through the OIG. And I'd be happy if people would work with me to sign on to that kind of legislation and force the issue through what is doing our job, not by rolling the dice and letting a court decide. So with that, I'll go to Alderman Garza.
Thank you, Mr. Chairman. I have to reiterate what Vice Chairman Irvin said. I think our track record stinks on behalf of FOIAing and what we're going to do with CPD, getting these things done. I'm not going to beat a dead horse because everybody said it correctly. I don't think there's any harm in waiting here. And with all due respect, I don't think Mr. Green is just going to walk away from the financial settlement. The definition of insanity is doing the same thing over and over and expecting different results. We can't keep doing the same thing over and over and over because we're not getting the results that we need or that the public wants to see. So I'm going to vote no on this, or I was hoping for a delay. And I think Alderman Irvin had a great point. If we can get something for direct introduction on Wednesday, then I think a lot of us would feel more comfortable. Thank you.
Well, I just committed Alderman Garza that I would put something together for Wednesday, and we can knock it out this afternoon and get it into the city clerk. We'll do that. But either way, we will have something that makes a move to get this information publicly available.
So are you asking for a delay then until this information goes out on Wednesday?
No, because the plaintiff has an agreement, a settlement agreement, and we want to move on that. But we can bifurcate in a way that provides this information to the entire public through the validated process of the Inspector General's office, which is where I would like it to go. If the administration disagrees with that, we can do it by legislation or direct order and put the issue through that way.
Point of information
Hold on a second. Alderman Brookins first, please.
Thanks. So then, Chairman, does that mean that you will commit to holding this matter if we voted out now, and then you will submit the legislation that you're talking about?
I could, I see what you mean. Yeah, I could hold it at the full city council, but I will have that legislation done.
All right. If I have your assurance on that, then I'm okay with it.
Point of information, Chairman.
Alderman Vasquez.
Yeah, it is about what you're proposing. So I know we couldn't have submitted anything past 10 a.m. today on Monday. Are you then suggesting it would be a direct introduction on Wednesday? And when would we be able to see any draft or anything if that's the case?
And why can't these things go on the same parallel track? They're not going together.
Well, I think that's a question that Renee Rodney has tried to answer, but I would like to get the legislation in as quickly as possible. I had a discussion earlier this morning about it and feel that the OIG is the most important route to go, but I will definitely have something for council on Wednesday.
Alderman Taliaferro for point of information or point of clarification.
Alderman Taliaferro.
Yeah, Chairman, can we get confirmation, or can your staff call the clerk's office before we end these proceedings today to get confirmation that the 10 o'clock deadline can be waived? Because if we set this as a precedent, that means from here on out, that 10 o'clock deadline would no longer exist. Because if we waive it once, we would have to waive it in the future for any other matter that's filed beyond the 10 a.m. Deadline. And if they've denied that request in the previous past, it opens up a door. If someone last month tried to submit and they refused because of the 10 a.m. deadline, perhaps this might open up a can of worms for them to have to explain why this particular piece of litigation allows for a waiver of that 10 a.m. deadline. So I would recommend calling the clerk's office before we end these proceedings and before vote, so that we can have clarification that clerk will indeed accept this after the 10 o'clock deadline has been passed.
I see your point, Alderman. Look, I'll put together the ordinance. You know, we probably could have worked on this sooner, you know, earlier in the week. I didn't see the broader aspect of it until yesterday, but I think
Point of information.
well, hold on just a second, Alderman Urban. I will have the draft ready, and I don't think I can bump over that deadline, but we could have it ready for a full vote in September once everybody gets a copy of the draft and works on it together. Alderman Urban.
Okay. Oh, I'm sorry. I mean, if we need be, Alderman Taliaferro, if we need to suspend the rules to introduce this on Wednesday, I think we can do that without violating the 10 a.m. order, given the circumstances that we have here. You know, the 10 a.m. order on Monday can still stand, and I'm not sure if that's a rule of council or just an ask of the clerk. But I think we could do some level of rule suspension to allow for this to be introduced on Wednesday, or it could be a direct introduction into committee at a time that the chairman deems so necessary.
And then somebody can send it to rules.
What? No. I'd like everybody to see.
In the practice of this new council, this new body. So I am very concerned. I am asking you to hold this. Let us in. We still follow with introducing it on Wednesday, and they all go together. I think that's what the members of the council are asking you to do.
All right, Alderman Haddon.
So many things since I last raised my hand, but I'll say I've really appreciated the discussion and debate on this. So Chair and Vice Chair, thanks for making space for that. And my question is in line with what I said earlier and with some of these most recent statements and you know, Chairman Wagaspack, it's for you, which is why can't we hold this now? What is the rush for this vote, especially given your own statements that the broader implications weren't something that you even considered until just the last day or so? We can't be the same council that just rushes things through because the administration wants them to happen. We are asking for time here. So I ask, is there a time sensitive piece that we're not aware of?
Alderman Haddon, when I said broader implications, I was referring to talking to the IG and figuring out what type of platform could be provided to put that on there. So not about the implications of the settlement. The settlement is fairly easy for me, that we have an agreement with the plaintiff's attorneys, with the plaintiff, and they have asked to move forward on this settlement agreement. So there wasn't a question there. It was the broader issue of who would be better suited to have validated information on their website or to put out publicly, and that was, to me, was the Inspector General.
Gotcha. But to the question of the speed of this, given the concerns, given the discussion that we've had, is there another time-sensitive piece that means that we need to vote on this today?
No, the implication here is that we have a settlement agreement that the law department has been working on with the plaintiff's attorney, and after several months, or longer than that, they've come to an agreement and have asked for the settlement agreement to move forward through the council. So,
And just one,
Alderman Smith.
Just sorry, a quick follow-up question to that, Chair, and it's for council. And that is just a reminder of when was the suit brought and how long have we been in discussions with them?
Renee might be able to answer that.
The suit was brought in 2015. But as far as negotiations to reach the figure that we've come up with for this proposed settlement, that began earlier this year.
Thank you.
Alderman Smith.
Yes, thank you very much. Thank you very much, Alderman Haddon. I had the same question. And when was I'll follow up by asking, and when was the settlement arrived at? That, you know, what's the time?
Approximately 2 weeks ago.
Mhm. And so this is the first opportunity to bring it to council.
Yes.
Yeah, I mean, I want to support what Alderman Wagisback is trying to accomplish. And the same risk that Alderman Hairston said, well, you know, someone could refer it to rules. Yes, that's a risk. I don't know that there's anyone on this call that would do that, because we all think that, I think this is a great idea. But on the flip side of that risk is the risk that should we delay the settlement, the plaintiff could change his demands. And the only thing that, what this plaintiff's agreed to was money. And he's entitled to do that. And he did it voluntarily. And that is his right. And if he was a plaintiff who was inclined to say, you know what, I don't care, I'm just going to keep this on, that's his right. So while I'm very curious that we feel that because of the times that we should, from a financial reason, hold an additional gun to our own heads instead of just doing what's right with regard to the issue. This plaintiff has decided to essentially abandon the issue on his own, but he's done us a service in raising the issue further. And if we don't have the gumption to raise it ourselves, that's shame on us. And in a sense, what I sense is a very good-hearted, well-intentioned effort to hold ourselves hostage. I just don't, and I think that with this new council, that we can make this happen. I also want to remind everyone that it is a part of the consent decree that the city do one of those other best efforts to maintain disciplinary records forever, indefinitely. And I think what Alderman Wagisback is suggesting is a really a fast way to get that done. So I think that there's a compromise here, which, and I don't think any of us doubt Alderman Wagisback's bona fides on the issue of progressivity or his word. So I think that it would be appropriate to move forward under the circumstances that we are in. When there is a settlement that is within a reasonable range of money and protects the city's financial interests, the plaintiff hasn't asked for anything more. It's fair to move forward. And I appreciate the cards and letters and the statements made by everyone from the BGA, who I fervently support, to the advocates of police reform. The issue of the records has plagued us for a really long time. And this plaintiff and his attorney have decided to put the battle down. And so now it's time for us to take it up ourselves. And I think that we've accomplished a lot by saying we want a good faith effort. We want to show that we're serious about it. And Alderman Wagisback just gave us a way through. So I applaud that thinking. And I think we should do everything to support it, because frankly, if we don't do it, then we will be waiting till September to do anything. So if this council agrees to suspend the rules on Wednesday to allow the immediate introduction on this of an ordinance, we're now ahead of where we were and where we would have been had we turned down the settlement or delayed it or done something like this and created a whole lot more uncertainty. So this is a new development and I appreciate it. And it shows, to my mind, how new and flexible this council has become. And that is how a legislature should behave. So again, I applaud what you're doing, what you're suggesting of doing, Alderman Wagisback. I'm sure that you can get this done. And I am also sure that you wouldn't do it if you didn't think we had a good chance of success to get it on the floor. Thank you.
Alderman Thompson. Alderman Thompson.
Thank you, Chair. I echo what my colleague was just talking about. I think we discussed this earlier where we could have subject matter hearings on the progress that we're making with our department and our FOIA, with the police department and all the other departments. And we're not precluded if we settle this case from continuing that. And I hear you say you're introducing legislation if we even need legislation. But we do need, as a legislative body, to hold the departments accountable and to have hearings on that. And so I echo what my colleague was just saying, that we can separate these two, vote on this matter today to settle the legislation, but not then ignore the problem and continue to work to solve that problem. So with that, I was going to move to pass.
Alderman, recognizing the motion to pass. All those in favor of the motion to pass this item, please unmute yourself.
Roll call.
All those in favor, okay. We have a roll call called, and I'll read through the roll call. Alderman Hopkins?
Yes.
Okay, thank you, ladies.
Okay, I'm going to read through the roll call. So Alderman Dowell,
No.
Alderman King,
No.
Alderman Sawyer,
No.
Alderman Mitchell,
No.
Alderman Harris,
Yes.
Alderman Beal, Alderman Beal, Alderman Sadlowski Garza,
No.
Alderman Thompson,
Yes.
Alderman Cardenas. Please mute yourself if you're not voting. Alderman Quinn,
Aye.
Alderman Burke, Alderman Lopez, Alderman Moore,
Aye.
Alderman Curtis,
Aye.
Alderman O'Shea,
Aye.
Alderman Brookins,
Aye.
Alderman Tabaris,
Aye.
Alderman Scott,
Aye.
Alderman Burnett,
Aye.
Alderman Urban,
Aye.
Alderman Taliaferro,
Aye.
Alderman Raboris,
No.
Alderman Austin, absent, Alderman Villegas, Alderman Mitz,
Aye.
Alderman Spizzato,
Yes.
Alderman Napolitano, Alderman Riley,
Aye.
Alderman Smith,
Aye.
Alderman Tunney,
Aye.
Alderman Osterman,
Aye.
Alderman Silverstein,
No.
Vice Chair Hairston,
No.
Alderman Wagisback votes aye.
Bill votes aye.
Okay, Alderman Beal votes aye. Was there anybody else who wanted to pop back in? Alderman Burke, Alderman Lopez? Okay. Ladies and gentlemen, I have 21 ayes, 8 nays. The motion passes.
Mr. Chairman, motion to
Motion to
reconsider the vote.
reconsider on the vote.
Motion to reconsider, Alderman Smith.
Motion to reconsider by Alderman Smith. All those in favor? All those opposed?
No.
No.
Okay, motion to reconsider fails.
No.
Thank you. Ladies and gentlemen, that concludes the business of the Committee on Finance today. I appreciate everybody's input. I will work on this ordinance as quickly as possible and have it in hand to you as soon as I can for your input. And I appreciate everybody's robust discussion. This is the way the committee should be in every committee. And I look forward to more of this discussion as we move forward. With that, do I have a motion to adjourn? the committee?
Motion to adjourn by Alderman Hopkins.
Thank you, Alderman Hopkins. That concludes the meeting of the Committee on Finance for today.